Good evening, councilors. My name is Fortunado. For 13 years I was a Superior Court judge. I've never clapped, but it's nice to be here when I do. And prior to that I was involved in Providence politics, so it's great to be back here. And one thing I learned in politics is to speak plainly and clearly. And I'm here to endorse the entire ordinance, but to address my remarks to section 4H about ICE and the cooperation or non-cooperation of Providence police officers. This act should be passed so that Providence can go on record formally and through law as being a sanctuary city. Legitimate concern on the part of city officials here and elsewhere as to whether or not, if one is a sanctuary city, funds can be cut off, as has been threatened by current administration in Washington. The simple answer is they cannot. They cannot be cut off if there's any respect at all for precedent. Let me begin, and I'll be very brief, but I want to get through this, and I see distinguished counsel is here. I'll cite a few cases that they may well be familiar with already. Indeed, on March 15th at a public gathering at the Athenaeum Library, both the mayor and the commissioner indicated that their research had basically come up with what I'm about to tell you. We begin with the recent decision on the healthcare legislation. But the operative language for our purposes here is, if the concept of penalty means anything, it means punishment for an unlawful act or omission is only when it can take place. There's got to be an unlawful act or omission. So the question becomes, can the federal government, either through the president or the Congress, compel law enforcement officials in Providence or anywhere else to help enforce the immigration laws? The simple answer is they cannot. This goes back to 1842, the case of Prigg versus Pennsylvania, where the Supreme Court said that when the federal government has exclusive jurisdiction over a particular issue, as they clearly do with immigration, they cannot compel local agencies to cooperate. Local agencies cannot frustrate them. They couldn't open City Hall as a haven for people trying to escape arrest under ICE detainers. By the same token, Providence police officials do not have to help. In the case of Prince versus United States, it may be recalled, that's P-R-I-N-T-Z versus United States, it may be recalled that the federal government wanted local law enforcement officials to run background checks for the purchase of guns. The Supreme Court ruled, through Justice Scalia and his majority at the time, that this was forbidden. You cannot compel the states to cooperate. Now you say, well, how does this work? Well, the Supreme Court bases its arguments on principles of federalism. There are two sovereigns, the federal sovereign and the state sovereign, and the feds cannot willy-nilly conscript the state to do their work, or the cities for that matter. The punishment, if there is ever to be punishment, is minuscule. And by that I mean, in those few instances when the federal government, through Congress, has sought to penalize states for not going along with a federal program, their fines or penalties cannot be coercive. They've got to be simply the kind that would encourage the states to go along. So, in a case called Cole versus South Dakota, the federal government sought to increase the drinking age, or compel states to increase the drinking age to 21. as an effort to reduce highway problems with drunk drivers. The case went all the way to the Supreme Court because the state of South Dakota did not want to participate in this program. The Supreme Court said, well, the penalty is all right because it's minuscule. We'll only cut off 5% of your funds. The point being that if this city goes and passes this ordinance, which I urge it to do, the federal people cannot come in and take away your education money, can't take away your health money, can't take away your building and parks money or anything of that nature. They would have to confine themselves to a very small percentage of money that goes to immigrants. But I leave you with the idea they couldn't even do that because they have no right to turn local law enforcement agents local law enforcement officials into agents of the federal government. This is absolutely crystal clear by the Supreme Court jurisprudence. I'd add one last thing, that in a way this protects the local police, because if the local police accompany ICE agents on a detainer warrant and storm around and try to arrest people, the ICE agents will not be looking at federal civil rights suits, but the local Providence police will, because they will be acting without a valid warrant issued by a court of law. Thank you very much. Thank you.